Good afternoon, everybody. Thank you for joining us. Today's guest is Jane Williams. Jane is a leading estate planning attorney here in the Kansas City market. My name is Bruce Glenn. So Jane, thanks for being with us.
Thank you for having me.
Appreciate it. So just kind of start off at a high level. Would you just kind of give us an overview of what your practice is, kind of what you focus on, and we'll dial into some details.
Sure, absolutely. So I am an estate planning and elder law attorney. And elder law does not mean that you can't come to me if you aren't elderly. But the estate planning portion of what I do reaches all ages and stages, and that has to do with helping people be prepared for incapacity or death through the use of documents, powers of attorney, of all nature, healthcare, financial, all of that, end-of-life planning, as well as a will or a trust. I call that the anchor document to the plan, and that's what we do. A person comes to my law firm, and we talk briefly about their assets and their families, and decide whether or not they need a will-based plan or a trust-based plan, and we go from there. The elder law portion of what I do helps people be prepared in case they need to qualify for certain long-term care benefits, either through Medicaid or through the VA. There's a program called VA Aid and Attendance, which benefits veterans, wartime veterans, or the spouses of a deceased wartime veteran.
So, and not to go deep down on the veteran side, because that is a pretty narrow slice of pie as far as who qualifies for it. But
that's correct.
I know Kevin, who's also a member of the IBE and a co-founder with me, he's done quite a bit of that in the past, but there were some rule changes a couple of years ago, so he's not seeing as much in that. Are you still doing quite a bit of veteran planning, or is that kind of dried up?
Well, probably not as much. But it's only really because people don't know about it. When Kevin and I were working together more in that realm, there was no look back period. And you could qualify 1 month with regard to how many assets you had, what your income was, what your medical expenses were. And then you could start on the benefit the next month. They found that was being abused. And so,
go figure, right?
Yeah, go figure. They changed the rule so that now you can't make those specific changes to be prepared and protect your assets. Then you can't qualify for 3 years after you do that. So it's called a look back period, just like with Medicaid, and most people have heard somewhere, church basement.
Yeah, it used to be 5 years, now it's 3.
Well, that's only for veterans.
Right.
5 years is still true of Medicaid. So we have to do that type of planning proactively.
The Medicaid, they actually pushed back further. There's veterans that went from 0 to 3, that's what you're saying.
Correct. Well, and actually that change in Medicaid was a pretty long time ago. I think it was 6.
Oh yeah, at least 10 years ago.
Yeah, so it's been a while since it's been 5 years. And you know, if you don't mind, it's important to me for people to understand what look back means.
Yeah, sure, go on.
Because people don't understand that. And what I tell them is, if you are in a nursing home or wanting to qualify for Medicaid, let's say, then the Medicaid folks are going to literally turn on their heel, and they're going to look back over your past 5 years. And that's what the look back means. They're going to look to see if you gave away any money that you could otherwise have been spending on your care now. And what many people think is, if I haven't done that, I can't qualify. And that's not true. They're going to apply a penalty period depending upon how much money you gave away during that period. And the penalty period starts from the application date. So you may have to self-pay for a period of time before you qualify. But 5 years doesn't start over, and it doesn't mean you're completely out of luck. So that's why we do this kind of planning, to make sure that we can proactively take care of those things.
And you are a proactive practice. You're not someone that heaven forbid, somebody passed away and there wasn't any planning done. that's not your wheelhouse. Your wheelhouse is people that are like folks joining us today, and probably folks joining on the video out on YouTube, so on and so forth. They're proactive about their money. They care. They're being ahead of the game. That's really your wheelhouse. What you're doing is because you can, it's like anything else. If you plan ahead of time, you can do a lot better planning.
That's right. And so I don't happen to practice in the probate realm, for example, after someone has died. And the elder law planning that I do is that proactive as opposed to what they call crisis planning.
Right.
That means somebody calls and says, Mom went into a nursing home last Thursday. What do I do?
Right.
And there are people who are great at that. But it takes a lot of staff and it takes a lot of time and effort to do that application process.
Right.
So that's not the part of what I do. I do the proactive part and allow people to let their investments continue to work for them while they proactively plan for those protections.
So one question that we get a lot here is, clients will come in and we'll be working with them on their investments and their planning and so on and so forth, and they'll say, we'll ask them ahead of time, do you have a will, or do you have a trust in place, and so on and so forth, and they'll ask, well, what do I need, and so I've got my kind of rule of thumb I go by between what somebody needs when they have just a will is going to be sufficient versus a trust, and some other more advanced planning. But what can you describe where your kind of lines are as far as that goes? I'm sure the soft lines, but your general parameters.
Sure, absolutely. And it just comes down to what I recommend. And they, as my children will tell you, no is one of the available answers. They can,
my kids don't know that, by the way.
Make a different decision than I recommend. But hopefully they've come to me for my expertise and they do take my recommendation. But a will is sufficient planning for some people.
Right.
It absolutely is. Three of the things I look for, it doesn't always depend upon how much money you have, whether or not you need a will or a trust. The three kind of markers that I use are, of course, if it's a taxable estate, which means that there will be an estate tax attached to it when you die, and right now that exemption level, the amount you can own without paying taxes is very high. Yes, so that isn't a big problem right now.
Although it looks like it may be changing.
It looks very much like it may be changing. So
we'll circle back to that. I'm going to ask you about some Washington, D.C. points that may be coming around.
Sure. So taxable estate is one given, but that's not very frequent right now.
Okay.
And the other two are, if you have minor children, they cannot inherit directly from you. And if you name them as beneficiaries or you put them in your will as a straight up beneficiary, they cannot inherit, and a court is going to get involved, and the court is going to create a trust for them on its terms. And it is going to be according to what the law says, which is at 18 they get it all.
Yeah, and that's a scary thought.
It is a
How many of us at 18 could have managed,
or 24,
a lot of money,
or 32,
or 65, right?
Exactly. So that's one of the things. If you have minor kids, I'm going to recommend a trust. And the other one is if you are a business owner. Because businesses, it's very, very difficult, other than a sole proprietorship. It's difficult to pass on a business or even liquidate that business without a trust, because it requires probate. And one thing that easily 90% of people who come into my office for planning believe that if you have a will, you avoid probate. Yeah,
and will actually means to go into probate.
It's like a ticket to probate.
Yeah,
That's
it's
right.
automatic. You have to get through probate to get a will actually executed.
If you have a will, if you decide on will-based planning, we do other things to help you avoid the probate court. But if you put instructions in that will that you want followed, a probate judge has to do that.
Right.
Now, no one else can do it without the court. So people don't understand that, and that's what they've learned. And in fact, I have people I have to work pretty hard to convince.
So staying on the easy side of things, or the simplified planning side, describe some things folks can do as far as if they don't want to have a full-blown trust, their home designation, their car designation,
Sure.
things like that.
Sure. So that is the main way that we avoid probate if you have a will-based plan.
Mm-hmm.
So your kids are grown, you trust that they can inherit your assets outright, and you decide you don't necessarily need for them to be protected from creditors, predators, and divorcing spouses.
Right.
Those are kind of my big
Well, those can be the
three.
same thing.
That's what I heard. That's right. Yeah, I've never.
You don't want Paul the pool boy getting the kids' money,
That's
right?
exactly right. That's exactly right. That's what I say. You may love your daughter-in-law now. You're not going to like her when she's walking out the door with the pool boy.
Right.
So you don't want her to necessarily get assets. But if you are willing to take that risk, frankly, then almost everything except a business and just a few other smattering of things can have named beneficiaries. And they do a literal end around, like football. They do an end around the will, and it avoids probate completely.
Right.
So a home in Kansas, also in Missouri, there's a statute in each state that says that you can pass your home on by operation of law to someone when you die. You file a beneficiary or a transfer on death deed.
Right.
You can pass your car on by going to, I say, the dreaded DMV, and adding a transfer on death, a TOD designation to your title. It will pass to that person by operation of law. Your stocks and bonds, your brokerage accounts, your bank accounts, all of those things can have payable on death beneficiaries.
Would you describe per stirpes a little bit?
So per stirpes is Latin. It's actually two words, PERSTIRPES. And loosely translated, I say it means per bloodline. And so if you are leaving something to your child per stirpes, that means if your child has predeceased you, that their kids will get it.
Right.
And if their kids aren't around, their kids will get it.
Yeah, so it just continues on as long as the
Goes into
bloodline generational.
perpetuity as long as your bloodline does, right? So that's a safe, typically a real good safety net to make sure that all of your beneficiaries aren't gone. So I know sometimes administrators of these plans, IRAs, 401ks, things like that, allow for per stirpes.
Yeah, some of the forms don't.
Some of them don't.
Correct.
That's right. That's what I've found as well.
Yeah, and so the challenge there, if it's not done that way, so let's say that I want my money to be split between after my spouse, then to be split with my girls. But if one of my girls passes away and they both have kids, well, I wouldn't want the other daughter getting everything left over and the first daughter's kids getting cut out.
They'd be left out.
So that's kind of how you can make sure you don't leave somebody's side of the family out if you.
That's exactly right.
Yeah.
Yes, and if you've planned well, and that per stirpes happens, and those kids, for instance, are minors, then if you've planned with a trust, there's a safety net for that within the trust to make sure that those kids receive it in the kind of manner that will keep it safe for their benefit.
Right.
And so, there again, even if you just have minor grandkids, that there are safety nets in the trust-based planning that you just can't put in a
regular 401k or IRA.
Yeah.
So that covers the will pretty good, and the designation as far as your home, your other real assets, boat, cars, things like that. If anything's got a title, you can put a designation on. Let's get more into the trust and why a trust makes sense. And you've touched on a little bit of it, but let's get on into the trust a little bit, if you don't mind.
Oh, absolutely. So how I explain it to my clients is that I consider a trust a bucket. And I know a lot of financial advisors use buckets.
Yeah, different buckets of assets.
Yeah,
Sure.
I think they stole it
Different
from me.
purposes.
But, no, but I just consider it a bucket because it's an entity in and of itself, your trust is. And to dissuade any fears, it doesn't mean you have to pick everything up from where it is. If people are investing with you and they have a trust, they're not going to say, oh, I have to take my investments away from you, Bruce, because I am going to put them in this trust.
Right, we just retitled the
Trust
account.
ownership means...
Or move it into the trust
That's right.
account.
It means changing titles or changing beneficiaries. And everything stays where you're comfortable with it. So that's one really positive thing. The other thing is you have great latitude in what instructions you want in your trust. You can say how you want it to be spent while you're living, how you want it to be spent if you become incapacitated. You can designate who is going to do that spending or that investing on your behalf. If you become incapacitated, you can decide how and when you want your children or other heirs, other beneficiaries to inherit. And you can decide, well, I want 10% or $10,000, whichever is less, to go to a charity before it goes to my kids. I call these off the top. They're specific beneficiaries, but that's something many people want to do, and they tell me, well, I want to leave something to Wayside Waifs. I want to leave something to the National Kidney Foundation, whatever it is.
Church or whatever.
Exactly, church often. But with a will-based plan, you're going to have to put that church as a beneficiary on one of your assets.
Right.
Or the probate court doesn't have any authority to give it to them. You can put all you want in your will, but if it doesn't go through probate, it's not going to get there. So with a trust, you can do all of that. And then what is called the residue, just like in wine, a lot of wine terms in estate planning.
I like that. You pour it over.
That's right. And you pour out what you want, and then the rest is the residue, right?
Yeah.
And then you have the opportunity to benefit your children or your heirs while not putting them in jeopardy. Because yes, you want to protect your hard-earned assets from walking out the door with the pool boy, but on the other hand, you also want it to benefit your kids, and they may or may not know what's best for them.
Right.
I am very cautious, and I would caution everyone who has a trust now or gets a trust to be careful of the language that's used. Because if you say, for example, when my kids turn 35, they shall, the trustees shall distribute 1/3 of the assets.
Yeah, you don't want to force it where they have to
That's
either.
exactly right. And that has been done always.
Sure.
Leading up to maybe the
Yeah,
last
really
10 years.
would you use the word may?
We use, they have the authority to withdraw up to 1/3.
Up to, yeah.
Up
That
to
gives a
1/3.
little more of an idea of you don't have to take the money out and blow it.
That's exactly right. They've waited all this time, and in the meantime, by the way, they're getting what they need for health, education, maintenance, and support. But they've been waiting all this time to go on the vacation of a lifetime, and so they say, I want to withdraw $20,000, taking on this big vacation. As long as it fits within that 1/3, then they pull that out. They take the vacation of a lifetime, but the rest of it stays protected.
Yeah, I like that. That's a good way to make sure the language is right.
It just makes all the difference. And I have also found that it's meaningful to kids. Mom and Dad put this in a trust. That's different than putting it in my lap.
Right.
You know, it does. There's just a little mental difference that says, you know, it's not just play money.
Right. And generally speaking, our clients that are proactive about their investment savings for retirement and their estate planning, their kids tend to be more up to speed as well.
It's an interesting thought. I don't know if that's true or not.
Yeah, it's probably not any study that says it, but I would assume so.
But you know, everybody.
There's no poor Rockefellers, right?
If you have more than one child, you got issues. You know, I have 3, and they are great kids.
Yeah.
But we've been very cautious about how they're going to inherit, just like you said. And yeah, we want it to be for their benefit, their kids' benefit, things like that. So
one thing on the trust, I always recommend when they go to a trust attorney, and the ones like yourself, will set up a power of attorneys your healthcare directives,
Right.
and then also something that's really important is a universal HIPAA.
Of course, the healthcare power of attorney that you sign also gives the people you've named in that universal HIPAA.
Right.
But we do a separate HIPAA authorization for that reason, because while you're living, you're making decisions.
Right.
And if a doctor comes into your hospital room and there's somebody there visiting you and they need to say, the doctor needs to say, is it okay if I talk in front of this person? You're actually giving them a HIPAA release.
Right.
But if you're unconscious,
yeah, you can't speak for yourself.
Can't speak for yourself in one way or another. This is what happened. This is what works. The HIPAA authorization that we do, along with the other documents.
So, Jane, where are we at right now as far as potential law changes in estate planning of Washington D.C.? What's out there on the horizon potentially?
The thing that's on the horizon actually right now is the change in the estate tax exemption. And there are other things at play in that, but that's kind of the main one. So right now, under the Trump administration, the estate tax exemption doubled.
Yeah.
And it's 11.7 something percent per person. So 23 point something per couple.
Right.
And there's something called portability.
Yeah, if you don't use all of yours, then it goes to your spouse, and then they've got a bigger chunk left over.
Yeah, so that's why you can really combine them for a couple in a little different way. But it was expected, honestly, that under a Democratic administration, that it will go down.
Right.
And my best guess, which was as good as my kids, which is none, that it would undouble.
Yeah.
Which is what has been proposed in the House now. So it looks like that's probably the blueprint for what's going to happen. So what that means is that if right now as an individual you have $10.5, $11 million right up to that, that if you die right now, there's no estate tax on the passing on of those assets, of your assets. But anything over that exemption level would have to be taxed, would be subject to estate tax. And what I'm saying to people is, we can do planning without tax planning if you want to, because you are okay right now.
Yeah.
But it's kind of a no harm, no foul to the way we do tax planning. So if you want to bump yourself into that, and be sure that you are covered if and when it changes. Again, no harm, no foul. Let's do it.
Yeah.
It's a little bit more complex planning. It costs a little more.
Touch on your thoughts about long-term care and maybe a little bit about life insurance if you talk to people about that and some say that when they have a lot of money.
Sure.
Yeah.
Sure. And life insurance, as a matter of fact, is often a really good alternative to people with taxable estates, because you can get life insurance in a manner that will pay your taxes.
Yeah, yeah.
Pay the taxable part of your estate. So that's one really good use for life insurance. Also, if you just say, I want, my kids may or may not benefit from my money because I may spend it.
Yeah.
But I want to be sure that
Leave
there is
something.
a benefit for them or for my grandkids. And life insurance is a really relatively easy way to do that.
Yeah.
I'm going to give you them caution about waiting too long.
Oh, yeah.
Because we don't know what too long is. And not just death, but making you less insurable.
Yep.
Health issues that come
Yeah, you
up.
may be able to get through underwriting.
Which is true also.
And it costs more the older we get, the more it costs too.
That's right. And as far as long-term care insurance, that's where you wanted to go, right, with long-term care insurance?
Yeah, there's different options out there. But
And there are, and
yeah.
there are some really good ones now where you don't use it or lose it.
Yeah.
Although I tell people, well, what if I never use it? It's been a big waste of money. And I say, you know, is your homeowner's insurance a waste of money?
Fire insurance.
You hope
yes.
your house doesn't burn down.
Yeah.
And you hope you don't need long-term care.
Mm-hmm.
Doesn't mean the money is wasted.
Right.
You're paying for protection.
Yeah.
And I'm good with that.
Yeah.
And there are such good, you can obviously speak much better to this than I, but there are such good options now about things that convert into long-term care or convert from long-term care to life insurance or investment opportunities, all kinds of different things that we didn't have.
Yeah.
We didn't have back in the day.
Speaking of documents, this is something I always recommend, and we do for our clients, is if you have the trust, we want to store, docu-vault that, right? Or even if you're traveling overseas, let's get your prescriptions list and docu-vault that, or your driver's license, your passport, copies of it, because if you get over in Europe, something happens, you at least know you can access it through our vault system. So I think that's important too. But
I do want to point out real quickly, I do practice on both sides of the state line.
Yeah, that's important because some people don't trust lines.
Right. Kansas and Missouri are both well within my wheelhouse, and my office, although I have a Missouri address, it is just across the state line at 435 in Holmes.
Right.
So Kansas folks really don't mind getting on 435 and then getting off, and Missouri folks are right there. So I just wanted to point out that I practice on both sides.
All right. Well, thank you very much. We appreciate you joining us, and you all have a great day. Thank you.